How can I expect an arbitration proceeding to be in Dubai, in the UAE? 2 seconds and we go into all the details. Hello everyone, my name is Maria Rubert, lawyer and arbitrator with a base in Dubai in the UAE for the past 15 years, and I'm happy to be with all of you today to share some information about my true passion, arbitration proceedings and arbitration. So this is a question that I touch with clients when they decide to initiate proceedings at the very beginning, or when they know that arbitration proceedings may be an option for them when they start having issues with a party. Yes. So I'm gonna try to divide the stages into initial stages and then the stages that we see once the case is transferred to the arbitral tribunal. So initial stages, usually parties start sensing that they have a conflict if they have a joint venture agreement, they have a distributor agreement, they purchase real estate, and and something is not going in the right direction, no payments, no construction, etc. Yes. So at that point, most arbitration agreements require our parties to send a notice saying, hey, you are not doing what you are supposed to be doing, and I am asking you to do what you are supposed to do. Yes, if you don't do this, please note that I will initiate arbitration proceedings. That's usually how amicable conversations go. Yes, so once that does not succeed, you usually go to the arbitral institution, and this information at the beginning could be different if you have an institutional arbitration or you have an ad hoc. Ad hoc is that you don't have an institution. What is an institution? ICC, London Court of International Arbitration, DIAC, yes? Those are examples. So usually you go to ICC, you go to DIAC, and you file the request for arbitration. And the request for arbitration has basic data. This is the party who hasn't done what was supposed to be done. This is how much I quantify the damage to me, or the compensation that I want, or the refund that I want, whatever it is that is sought. Then the role of an institution is very important because they do 2 crucial things: collect payment from the parties and appoint the arbitral tribunal. So it's important the arbitral tribunal knows about the law. If you have a contract that is governed by New York law, the lawyer is going to be different. The lawyers and arbitrators will be different than when a contract is governed by Spanish law. Yes, so this is the role of arbitral institutions. They track the right profile. Also, if it is a construction dispute, you will need a pedigree of arbitrator different from a joint venture dispute. Examples, or a software dispute, another example. So the pedigree is different, the expertise of the arbitrators. So usually institutions have a pool of arbitrators with different backgrounds, so they are much faster to locate the right arbitrator than could the courts, because if you don't have an institution, you may need to go to state courts, and this may take a long time. And when they find you, the profiles of the arbitrators may not be the right ones. Yes. So this is the initial stage: collecting payment, appointing the tribunal. Yeah. And then the case is transferred to the tribunal. Tribunals could be one arbitrator, or it could be 3. Yes, so it's transferred. If it's 3, the chair usually takes the role of the leading arbitrator, and communications go to and from the chair. So usually what they do is to summon parties to a preliminary meeting. And since COVID, most of these meetings are online. At the preliminary meeting, what parties do with the arbitrators is to go over the process. This is the most important. Also, they go over the arbitration agreement, they reconfirm they go over the governing law, they reconfirm, they list the parties, they list where is inserted the arbitration agreement, etc., etc., etc. But the most important is the procedural table that is agreed. So what is it agreed on most scenarios by the parties? In some cases, if the parties do not agree on the timings and the process, the arbitrators must hear both, and then if they hear both, they can decide the best way forward. But usually a timetable will have statement of claim, statement of defense. Will also include the respective replies. This is what we know as the documentary or the written pleadings phase. After the written pleadings, and in most scenarios, you will see that parties are expected to file all evidence. So if they have witness statement, they should include it in those documents. These are the fast-track arbitrations. In some cases, this is not possible to be agreed, so you will have the witness statements after the initial pleadings. After the initial pleadings, you may also see a discovery phase. So what is discovery? Discovery is very big in common law countries, not so big in civil law countries. So why? Because it's about good faith. And most common law countries, they have faith in that people will do the right thing. Civil law countries usually don't have so much faith. Yeah. This is at the root, the simple root of the different processes between the common and civil. So in discovery, pretty much, parties will ask each other for documents that they don't have. So I know I sent an email, or I know I sent a WhatsApp, but I don't have that number anymore, so I want the disclosure of that document, right? So usually we follow here in the UAE the red fern schedule. So parties list the documents, the reason why they think these documents should be produced, and then there are a couple of back and forth between the parties, and then the tribunal decides on which documents need to be produced or not. After the discovery, usually we have the hearing preparation. So sometimes there is a hearing or a meeting to prepare. So who is going to record, which company is going to record, how much is that going to cost, how many witnesses do you plan to have at the hearing, also skeleton arguments, the bundles. The bundles are with all the documents that are submitted during the arbitration. Usually the claimant is in charge, after consultation with the respondents, to prepare a bundle with all the documents listed. And then when you prepare the skeleton arguments, which are the arguments that will be used for the hearing by lawyers, the skeleton arguments will make reference to the bundle, and the bundle has page numbers. So it's easier for everyone to have it in front on the date of the hearing and say, please, let me guide you to page TTT. You will read this, and it's easier for everyone to be on the same page. Imagine a hearing saying, no, please everyone refer however you want to refer to the statement of defense. This could be very chaotic. So this is the way it's done. Then the hearing takes place, usually lasts 3 days. That's the common. Smaller cases will take place in 1 day, and bigger cases usually in 5 days, and super big cases in 2 weeks or more. Yeah, but the norm in our practice is about 1 week of hearings, and this is extremely demanding because you need to be prepared for what you are ready to expose, but also for any question and any matter that may arise. So you need to know exactly every single piece of paper that is being submitted to the arbitration. So I hope that this is of help to you if you may be about to commence proceedings, if you are already in proceedings, if you are a law student, if you are an arbitration student. Please feel free to shoot any Any questions that you may have on this very interesting topic of international arbitration, I'm more than happy to address them if they can be turned into a general question. As you know, I always welcome general questions. If you have learned a little bit, please do like my video, please do subscribe to my channel, and also please feel free to follow me on social media to get to new information, and to new data that I share on daily and weekly basis in my channels. Thank you very much for your loyalty.